Namaste. It is my pleasure to have a discussion with you about ragging and its legal implications with reference to the provisions of Indian Penal Code and anti-ragging laws. The historical as well as the social background of ragging and its definitions as per our legal system are beautifully explained by the other legal luminaries. But I think, being a lawyer, I have to explain its gravity by focusing on the penal laws. As far as the legislations in this respect are concerned, State of Tripura is the forerunner among the states by enacting Tripura Educational Institutions Prevention of Ragging Act in 1990, followed by similar legislations by many other states. The state of Kerala passed the Kerala Prohibition of Ragging Act 1998, and hereinafter I may term it as the Act. The Honorable Supreme Court of India, in the landmark decision Vishwajagriti Mission versus Central Government, has laid down certain guidelines and directed UGC to bring these guidelines to the notice of all educational institutions. Several committees were constituted to address this problem. Raghavan Committee is the most famous among those. It was constituted in 2006 and submitted the report in 2007. The committee suggested 50 recommendations and the Honorable Supreme Court recommended the following for implementation. They are: anti-ragging movements by institutions, undertaking by freshers and parents, protectorial committee, identification of ragging-prone zones, sensitized society, failure to prevent to be treated as negligence, carefully guarded accommodations, endorsement in migration certificates, action against institutions for not taking actions, students to approach institutions. In spite of all these efforts, ragging continued discreetly. The anti-ragging movement in India attained a new momentum with Aman movement. In 2009, UGC issued regulations to prevent ragging in higher educational institutions. This extends to all the premises, whether located in the campus or outside, and also includes means of transportation, whether public or private. It shall apply to all the institutions, including those functioning under the central, provincial, or state acts, deemed universities under the UGC Act 1956, and all other educational institutions. The key features of UGC regulations are: it ensures exemplary and justifiably harsh punishments. When institutional arrangements for action are unsatisfactory, a first information report must be filed. Speedy disposal of ragging cases in courts. Introducing in educational curriculum a subject relating to ragging. In the prospectus, it should be clearly stipulated that if the applicant is found to have indulged in ragging in the past, or if it is noticed later, admission may be refused or shall be expelled. Government to launch programs giving wide publicity about ragging and the consequences. Authorities and functionaries of the concerned institutions and their role shall also be open to scrutiny. Most important is the formation of anti-ragging committees and squads. These are to be nominated and headed by the head of the institution and must consist of representatives of civil and police administration, local media, NGOs involved in youth activities, representatives of faculty members, non-teaching staff and parents, representatives of students belonging to the fresher as well as senior students category, and there must be a diverse mix of membership in terms of levels as well as gender. Anti-ragging committees shall monitor the function of the anti-ragging committees as well as squads, whereas the anti-ragging squads to make surprise raids on hostels and other places vulnerable to incidents of and having the potential of ragging. A student during the admission process has to file an affidavit along with the parent's guardian's signature stating that he or she will not be ragging other students directly or indirectly. Every fresher student admitted to the institution shall have a printed leaflet detailing to whom he or she has to turn to for help and guidance for various purposes, including addresses and telephone numbers, so as to enable the student to contact the concerned person at any time. Identity of informants of ragging incidents is fully protected. Now, let's have a look at the salient features of the Kerala Prohibition of Ragging Act 1998. As we notice, it is a very small act. It has just 9 sections. The important sections are Section 2, Definition of Ragging. Display of disorderly conduct, doing any act which causes or is likely to cause physical or psychological harm or raise apprehension or fear or shame or embarrassment to a student in any educational institution, and it includes a. Teasing, abusing of, playing practical jokes on or causing hurt to such student, and b. asking the student to do any act or perform something which the student will not in the ordinary course willingly do. Let me explain it. All the given acts will amount to ragging. Any act by a senior student that prevents, disrupts or disturbs the regular academic activity of any other student, or exploiting the service of any student for completing the academic tasks assigned to an individual or a group of students, or any act of financial burden put on any student by other students, or any act of physical abuse including all variants of it like sexual abuse, homosexual assaults, stripping, forcing obscene and lewd acts, gestures, health or person, or any act or abuse by spoken words, emails, posts, public insults which would also include deriving perverted pleasure, vicarious or sadistic thrill from actively or passively participating in the discomfiture to freshers or any other student, or any act that affects the mental health and self-confidence of a fresher or any other student with or without an intent to derive a sadistic pleasure or showing of power, authority or superiority by a student over any other student. Section 3 deals with prohibition of ragging, that is, ragging within or without any educational institution is prohibited. Section 4 deals with penalty for ragging. Whoever directly or indirectly commits, participates in, abets or propagates ragging within or without any educational institution shall, on conviction, be punished with imprisonment for a term which may extend to 2 years and shall also be liable to a fine which may extend to 10,000 rupees. Section 5 is the dismissal of student. Any student convicted of any offence under Section 4 shall also be dismissed from the educational institution, and such student shall not be admitted in any other educational institution for a period of 3 years from the date of the order of such dismissal. Section 6 is suspension of student. Whenever any student, or as the case may be, the parents or guardian or teacher of any uneducational institution complains in writing of ragging to the head of the educational institution, the head of that educational institution shall, without prejudice to the foregoing provisions, within 7 days of the receipt of the complaint, inquire into the matter mentioned in the complaint, and if prima facie it is found true, suspend the student who is accused of the offence, and shall immediately forward the complaint to the police station having jurisdiction over the area in which the educational institution is situated. Whether on inquiry by the head of the educational institution it is proved that there is no substance prima facie in the complaint received under subsection 1, he shall intimate the fact in writing to the complainant. Section 7 is deemed abatement. That is, if the head of the educational institution fails or neglects to take action in the manner specified in Section 6, when a complaint of ragging is made, such person shall be deemed to have abetted the offence of ragging and shall, on conviction, be punished as provided for in Section 4. As per UGC regulations, the guidelines lay down that on receipt of any information concerning any reported incident of ragging, the head of the institution shall immediately determine if a case under the penal law is made out, and if so, either on his own or through a member of the anti-ragging committee proceed to register an FIR within 24 hours of receipt of such information. All India Council for Technical Education AICTE has created All India Council for Technical Education, Prevention and Prohibition of Ragging in technical institutions, universities including deemed to be universities imparting technical education, regulations 2009 under Section 23 and Section 10 of the AICTE Act 1987. Medical Council of India has made Medical Council of India Prevention and Prohibition of Ragging in Medical Colleges Institutions Regulations 2009 under Section 33 of the Indian Medical Council Act 1956. Now let's see how Indian Penal Code deals with ragging. The term ragging is not defined in IPC, but for the purpose of initiation of proceedings, the definition as mentioned in the Act can be used. The main provisions of the Indian Penal Code that could be charged along with the offence of ragging are Section 107 to 119, abetment. A person who instigates any person, engages with other person, or aids another person to rag will also be tried and punished for ragging. Section 120B, criminal conspiracy to rag. When two or more persons agree to do ragging and do any act in pursuance of that agreement, this section will be attracted. Section 143 and 147. Whoever is a member of an unlawful assembly to rag shall be punished under Section 143, and if they use force or violence while ragging, it would amount to rioting. That is Section 147. Section 292 and 293. Violation of decency and morals through ragging. That is selling, distributing, publicly exhibiting or circulating any book or pamphlet containing obscenity can be punished up to 5 years. If it is given to a person below 20 years, then punishment can be up to 7 years and fine. Section 294B, obscene acts and songs. Anyone who does any obscene act in any public place or utters any obscene word shall be punished under this section. If the victim dies in consequence of ragging, then Section 302 applies, or Section 304, that is culpable homicide, applies depending on the situation. Section 305, abetment of suicide of child or insane person. If any person under 18 years of age commits suicide, whoever abets the commission of such suicide shall be punished with death or imprisonment for life. Section 306, abetment of suicide. If any person commits suicide, whoever abets the commission of such suicide will be punished. Section 307, attempt to commit murder. Section 308, attempt to commit culpable homicide. Section 323, if the person causing injury while ragging and was aware of the fact that he is likely to cause such hurt will be punished under this Act. Section 324 is voluntarily causing hurt by dangerous weapon or means. Section 325, voluntarily causing grievous hurt without weapon. Section 326, during ragging, if any person is hurt voluntarily by means of any instrument which might result either serious injury or death, then such accused shall be punished under this section. Section 341, wrongful restraint. An act of obstructing the way of other students during ragging in order to cause trouble or prevent them from proceeding towards any direction in which he or she has a right to proceed. Section 342, wrongful confinement. It's an act of confining other students in a room or place in order to trouble them or harass them. Section 350 and 351, criminal force and assault. Using force for the purpose of causing fear or annoyance to the person to whom the force is used will be punished for assault. Section 354. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty will be punished under this section. Section 383 and 384. Extortion and punishment for extortion. Putting a person in fear of any injury induces the person to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security commits this offense. Section 447. Criminal trespass. Whoever enters upon property in the possession of another with intent to commit an offense or to intimidate, insult or annoy, that is said to commit criminal trespass. Section 506. Criminal intimidation. Whoever threatens another with any injury to his person, reputation or property or to the person or reputation with intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do or to omit to do any act which that person is legally entitled to do as the means of avoiding the execution of such threat commits criminal intimidation. Section 507. Criminal intimidation by an anonymous communication. Section 509. Whoever intending to insult the modesty of any woman utters any words, makes any sound or gesture or exhibits any object intending that such word or sound shall be heard or that such gesture or object shall be seen by such woman or intrudes upon the privacy of such woman is committing this offense. Section 511. Punishment for attempts. Attempts to commit any or all of the above mentioned offenses against the victim or victims is an offense. Moreover, if the victim is a minor and the offense is of sexual nature, relevant provisions under the POCSO Act will be attracted. Provisions of Scheduled Caste and Scheduled Tribe prevention of atrocities is likely to be attracted if the victim belongs to the said category. Involving in ragging will spoil your future for sure. Please do stay away from it. Thank you.